Hello, everyone, and welcome to my case summary of the U.S. Supreme Court's decision in Wickard versus Filburn. This is a 1942 decision. It was unanimous, and it was by Justice Jackson. And oh boy, if you are in a constitutional law class, this is a relevant case. This case single-handedly blew up the Commerce Clause, made it very, very powerful in scope, and gave Congress a lot of power to regulate. So yeah, without further ado, let's get into the facts. Filburn filed a complaint against the Secretary of Agriculture, Claude Wickard. Filburn wanted to prevent the enforcement of the marketing penalty that was imposed by the Agricultural Adjustment Act of 1938 for his violation of the quotas of wheat crop established. He wanted the court to give declaratory judgment that the wheat marketing quota violation of the act was unconstitutional because it was invalid under the Commerce Clause of the U.S. Constitution. So the way that the Agricultural Adjustment Act works, it's a Great Depression era legislation. It controls the volume moving in interstate and foreign commerce in order to avoid surpluses and shortages and the consequent abnormal low or high prices and obstructions to commerce. So Filburn, what he argues is that production and consumption of wheat are local and at most only indirectly affect interstate commerce. So remember that, yeah, the Commerce Clause says interstate commerce in it. The text of the Commerce Clause does not mention purely local commerce. It doesn't mention local activity. So Filburn's kind of making what you could say is a textual argument. What does the Supreme Court say, though? Well, they announce a pretty big new rule. They say that activity may be reached by Congress if it exerts a substantial economic effect on interstate commerce. No form of state activity can constitutionally thwart the regulatory power granted by the Commerce Clause to Congress. Therefore, the reach of that power extends to those intrastate activities. That means activities which are happening inside a state and not outside of it, which in a substantial way interfere or obstruct the exercise of the granted power. The substantial effect is what's important, not whether it's direct or indirect. So yeah, this establishes the substantial effects test. If something has a substantial effect on interstate commerce, it doesn't matter if it's purely local. In the eyes of the Supreme Court, Congress gets to regulate it under the Commerce Clause. So pretty big deal. Yeah, so there are the key components of this decision. As I just mentioned, there's the substantial effects test. Secondly, there's deference to the economic judgment of Congress. I think the Supreme Court is kind of beating back some of the judicial activist types or the interventionist types on the court. They had retired by this point, but they were more conservative and they were really active in trying to take down New Deal legislation by FDR. They thought that it was totally out of the bounds of the Commerce Clause. They thought it was, just economic authoritarianism. They can't have that, that Congress is powerless on those things. For example, there's cases like Hammer versus Dagenhart from 1918, Carter versus Carter Coal Company from 1936. And so this case comes along and really sort of blows that whole interpretation up, says, no, this is the way that we're going to do things from now on. We're going to be more respectful of Congress's judgment. Now, whether or not they were too deferential to the judgment of Congress is a policy question. It probably was helpful that at this point there was a Congress that generally agreed with members of the Supreme Court on the importance of economic regulation. Heavily Democratic majorities in both chambers of Congress. And as I've been saying all along, Congress's power under the Commerce Clause is now wider than before. It's even wider than it was in the case before this, the Darby lumber case, where Congress essentially got even more power under a sort of implied powers focus of the Constitution. But in this case, they don't actually mention implied powers. They just say, well, this is the Commerce Clause. The Commerce Clause says that you can do this because it allows regulation of intrastate activity as long as that activity has a substantial impact on interstate commerce. So yeah, let me know what you think of Wickard v. Filburn in the comments. Do you agree with it? I really hope that this video is helpful for those of you in constitutional law. Hopefully you can get an A++ on your constitutional law exam. As always, please leave a like, comment, or subscribe to the channel. I love making these videos, getting stuff about the law out there. Thank you so much for watching, and I look forward to speaking to you in the next video.